Welcome to the Spot On Insurance Podcast, sponsored by Insurance Licensing Services of America, ILSA. This is Ted Tavares.
And this is Arlene Tavares.
Before we get started, remember to click on the subscribe button so you don't miss a single episode.
Hello and welcome to Spot On Insurance. This is your host, Doug Foresta. I want to remind you before we begin that if you have not subscribed to the podcast, please go to iTunes and subscribe. We have so many great episodes on all different topics that compliance, regulatory compliance and insurance, lots of different great information. So I definitely encourage you to subscribe. Today, my guests are Dan Oberdorfer and Nicole Faulkner from Stinson Leonard Street. They are both attorneys there. And our topic today is a timely one. It's about marijuana in the workplace, job performance, drug testing, discrimination, reasonable accommodations, and more. Dan and Nicole, welcome.
Thank you.
Thank you, Doug. We're happy to be here.
Thank you. So I thought where we'd start is, I know that the current landscape of where we are with legislation at the state level in terms of marijuana is sort of all over the place. So where are we right now when it comes to state level legislation with marijuana?
Sure. Thanks, Doug. Well, like you said, it is kind of all over the place, but it's certainly something that is affecting employers on a daily basis. Right now, there are 29 states and the District of Columbia that have some form of legalized marijuana. 8 of those states have legalized recreational marijuana, but what you'll hear us talk about today is more on the medical marijuana side, as that really poses some of the bigger challenges for employers. These states that have legislation legalizing marijuana, they're doing a couple of different things. They're primarily decriminalizing the use or possession of marijuana. They're providing some civil liability protections to people like doctors that are prescribing it, or of interest to Dan and I, to attorneys that are advising companies on how to navigate through it. And then, of course, regulating the manufacturing, distribution, use, possession, all of those things. I think as important to employers, these regulations sometimes will address how employers have to look at the marijuana in the workplace. Certainly some challenges that employers are having to work through to navigate through all of those tricky things and figure out how they apply to your particular business, especially in light of the fact that all of these 29 state statutes are completely different in some respects.
One of the questions, I think I'll ask you this here, is about if I am given that there are so many, like you said, so many different statutes, if I'm an employer with offices in multiple states, is it possible to have one consistent policy across different states?
I think I'll jump in on that one. It is, but it's really a challenge to do that because the laws are different. And as Nicole was alluding to, there are a number of states that have medical marijuana laws that then also provide an anti-discrimination provision that states that the employer cannot discriminate against the employee for taking, quote, legally, medical marijuana pursuant to a prescription from a doctor. And then there are a handful of states, 3, that actually say if you drug test an employee who's a registered medical marijuana user and that person tests positive for marijuana, you can't fire that individual. So if you're going to, as an employer, if you're operating in all 50 states and you want one single policy, you need to go to the most restrictive kind of policy. So you'd be following the lead of those states that have anti-discrimination provisions, but they also say you can't fire somebody for testing positive on a drug test for marijuana if they're a registered user under the medical registry. And that limits your flexibility in the 47 other states. So many companies that are operating in all 50 may be looking to have a couple of different policies, one that applies in the more restrictive states and then another one that applies in the less restrictive states.
Thank you. So of the states that have legalized marijuana in some way, how are they addressing the employment-related issues that might arise from marijuana use? I
think that you can easily categorize them into three sort of buckets. The first is there aren't any states that have passed medical marijuana or other marijuana legislations that require employers to accommodate the use, possession, or being impaired in the workplace. And that's key, and we'll talk about that in a minute, about being in the workplace. So there's this lower level of states that really have just passed the legislation and told employers, look, they have the right to do this, but you don't have to allow them to be impaired or use it in the workplace. And that's the biggest chunk of states. There's 19 states that really sort of stop there. The next level, 12 states, as Dan alluded to a minute ago, they have enacted non-discrimination language. So basically, they're telling employers, all of these things, yes, you don't have to accommodate use or impairment in the workplace, but you can't discriminate against someone just because they are a registered medical marijuana card holder. So that's the non-discrimination chunk of states. And then the third tier, and this is those three states, Arizona, Delaware, and Minnesota, that Dan mentioned earlier, that have the most protection for employees, is employers are not able to take an adverse action if an employee who has a registered medical marijuana card tests positive on an employer's drug test. So the employer can't take an action just because an employee tests positive when that employee presents a valid card. Again, the overarching theme there is still that employers are not required to accommodate use in the workplace. So if an employee is showing up impaired or has medical marijuana on their person in the workplace, those are not things that the employer has to look the other way for.
Well, that would be like, I'm thinking about alcohol, for example, right? I mean, alcohol is legal, but it doesn't mean that I can show up to work drinking a beer.
And that's really the main point here, that even though we have this overlay of differing laws in the 50 states, the main point is that when an employer is evaluating an employee's performance, if the employer focuses in on the performance, was the employee following the guidelines at work in terms of his or her job? Was the employee acting dangerously? Was the employee threatening another employee? Did the employee adhere to the employer's attendance policies, etc.? None of these laws say you can't focus on your normal kinds of employment decision making. And if the employee's performance is poor, generally then the employer can go ahead and make an employment decision whether to discipline the employee or fire the employee, whatever's appropriate in the circumstance. The one caveat, and the reason I said generally, is because there have been some new cases that talk about whether reasonable accommodations for employees who are using medical marijuana. And there you may have to engage in what they call the interactive process and talk to the employee about what's causing the performance deficiency, and is there some reasonable accommodation that can be provided to bring the employee's performance back up to a satisfactory level. And so that's a little bit of a complication here, but it's really no different than anything else in the workplace. And generally, employees who have got a prescription for medical marijuana are going to have an underlying medical condition that may qualify as a disability under disability laws, and therefore need to be accommodated anyway.
Well, I wanted to ask you, with that, I wanted to ask you a follow-up to that. So if I'm an employer And can I legally ask an employee who, let's say, it tests positive for marijuana in some way, can I ask them to produce a medical marijuana card, or is that a HIPAA violation?
Well, generally, most employers are not going to be covered by the HIPAA laws.
Okay.
Obviously, if your employer is a hospital or a doctor's office, they are covered by the HIPAA laws, but most employers are not. And so the statutes, particularly like the one here in Minnesota, if the individual tests positive for marijuana, one of the things the employer should be doing is asking for an explanation. And if the explanation is, I'm a registered medical marijuana user, of course the employer is within its rights to say, can I see your card? And I need to have proof of that. And we're not just going to take your word for it. So generally, I don't think that that's a problem if the employer has a good basis for doing so. I don't think employers should be going around their workplace and asking random employees, are you a registered medical marijuana user? I mean, it's in effect asking, do you have a condition that may rise to the level of a disability under the ADA, under the Americans with Disabilities Act? And that would be a prohibited kind of inquiry. But if there's a real basis to do so, like they just failed a drug test, then it would be within the employer's right to say, is there a good explanation as to your failure? And if the answer is, I'm taking marijuana as a medical prescription, the employer would be within its rights to say, can I see your card, or can you prove to me that this is true?
Spot on Insurance is sponsored by ILSA, Insurance Licensing Services of America, America's premier licensing and regulatory compliance experts. To learn more about ILSA and the services they provide, visit ilsainc.com. You mentioned the ADA, and we've touched a little bit on the on the importance of obviously not having a disability discrimination lawsuit. Can you say a little bit more about, in general, what employers need to be careful about in order to avoid potential disability discrimination lawsuits when it comes to medical marijuana users?
I think the first rule is that employees should be evaluated based on the employee's performance and not on anything else. They shouldn't be stereotyping employees. And then if, in fact, it turns out the person is on the medical marijuana registry, I think most employers in most situations should at least want to inquire whether or not there's a disability that's causing the performance deficiency. And if so, explore whether or not there's a reasonable accommodation that can assist the employee bring his or her performance back up to a satisfactory level. But the focus always should be not on the medical marijuana use or on the underlying disability, but on the performance issue. That said, as Nicole said early on, employers do not have to accept an employee using or possessing marijuana in the workplace. So if that's the issue, that the individual has brought the medical marijuana to work, that's something that can be disciplined, that the employer can discipline for. Well,
one of the things also that I want to ask you about was, of course, there's right now a discrepancy to some degree in the states where marijuana is legalized in some form between the state law, state regulations, and of course the federal law. Marijuana is still not legal under federal law. Is that correct? Am I correct in understanding that?
That's correct. So, in terms of the discrepancy,
yes,
there are a number of ways in which this plays out. There was a case in Colorado a couple of years ago in which the individual was fired for medical marijuana use. And the individual cited to Colorado's use of illegal substance statute that said the individual can't be fired for, legally using some kind of substance. These laws are aimed primarily at tobacco and drinking, but they don't allow they don't give somebody the right to be drunk at work. But you can't fire somebody if they're smoking cigarettes. Anyway, the Colorado courts looked at this and said, even though marijuana is legal under Colorado law, it's not legal under federal law, and therefore upheld the firing and said the fact that Colorado has legalized marijuana use, including medical marijuana use, did not immunize this employee from termination.
Yeah, and I'll jump in too, because I think that this Colorado case, is a great example. When you look at the Colorado statute, Colorado's in that group of states that I talked about earlier that is at the lowest rung of protection, really. So they do not have the non-discrimination language in their statute. And so, by contrast, there was a case earlier just this year in Rhode Island, and Rhode Island does have that non-discrimination language in their medical marijuana statute. So while federal law can say it's still a crime and this drug is still an illegal substance, and the state can say the opposite, well, it's not a state crime, the federal laws don't prevent these states from making employment regulations. So non-discrimination, for example. So in Rhode Island, this case, the exact opposite came out, in that the employee had disclosed on her application that she would not be able to pass the employer's drug test, and that she wouldn't, because she's a medical marijuana card holder. And the employer just refused and failed to hire her simply because she was a card holder. Well, because Rhode Island, different from Colorado, has non-discrimination language in their statute, the employer lost. The employer basically took an adverse action by not hiring her just because she was a card holder. And that's how those non-discrimination statutes really come into play.
So it really depends. It really depends what state I'm in and how that statute was written. Is that fair to say?
Very much so.
I'm really curious, and this question is for both of you, Dan and Nicole. What do you see as the biggest mistakes that employers make when it comes to handling medical marijuana in the workplace? I mean, I know you may have addressed some of that, but I'm really curious in your experience what you see.
Reaching a quick knee-jerk kind of decision if they find out the individual is on a medical marijuana registry, that all of a sudden they're going to limit that person's responsibilities or fire that person or start watching that person a little more closely. That's, I think, mistake number one is having some preconceived notion that because they're on a registry, they deserve heightened scrutiny or even heightened discipline. And the way to resolve that is to really focus in on the individual's performance. And it may be that you have an individual who does have a medical condition for which marijuana was prescribed, and they perform spectacularly and do their job, and the employer really shouldn't be interfering with that kind of doctor-patient prescription relationship.
Well, I was just going to add on to that, and I think that under the same theme of focusing on the performance, especially in states like Minnesota, which we see a lot practicing here, having the statute that is really restrictive in terms of you can't take an adverse action if there's a positive drug test. We see a lot of employers wanting to jump right to the drug testing when they're doing so lawfully, when instead of moving to drug testing, there's a perfectly legitimate performance issue that could be addressed completely outside of the medical marijuana statute or even a lot of just general drug testing statutes around the country. Employers want to have that positive test in their hand instead of just addressing the performance itself. And that's where you can get into trouble once you have a positive test. Some of these statutes come in and apply some protections to the employees.
Just to throw one little wrinkle in there to make it more complicated, because the law here is unsettled. We've got a number of states that have passed laws, and perhaps additional states will pass laws. For the most part, the federal government has been sitting on the sidelines as all this has happened. But with the change of administration a year ago, it may be that the Trump administration starts to get more aggressive in this area and starts to push back on some of these states that are legalizing marijuana for recreational use and also perhaps for medical use. And so they have some tools at their disposal, some things like under the Drug-Free Workplace Act, federal contractors need to certify that they have drug-free workplaces. And the Trump administration could start to push back and say, we need you to have stronger enforcement policies on medical marijuana in that area. Similarly, OSHA, which governs safety in the workplace, could take a strong position on medical marijuana and push back there as well. And so I think, as we're looking forward, employers should be mindful of changes in the legal landscape, because some of those changes could change the way employers should respond to these kinds of issues.
Well, it sounds like we're going to have you back to, I already see the title of that episode, Changes in the Legal Landscape. So.
Part two.
Yeah.
Part two. My guests today have been Dan Oberdorfer, attorney at Stinson Leonard Street, as well as Nicole Faulkner, who's also an attorney at Stinson Leonard. Dan and Nicole, if people want to reach out and, maybe they need some assistance in this area, what's the best way for them to do that?
They could call either of us. We'll give you the phone numbers. I'm at 612-335-1832.
And I'm at 612-335-1675.
Or they can go on to stinson.com, which is our firm's website, and locate us and send us an email.
Dan and Nicole, thank you so much for joining me today.
Thank you, Doug.
Yeah, thanks for having us.
Thank you.
By the way, our show notes and bonus resources can be found on spotoninsurance.com. Subscribe now so you don't miss a single episode.
Thanks for joining us.